replacements or curtailments or enlargements of any part, according to the needs of those who are to use that path. A careful reading of the debates in the Constituent Assembly leads to this premise or assumption. If the path needed widening or narrowing or changing, the limits could be changed. The mandate of Article 37 is primarily addressed to the Parliament and state legislatures. But insofar as courts of justice can indulge in some judicial lawmaking within the interstices of the Constitution or any statute before them for construction, the courts too are bound by this mandate. Another valid and significant distinction is that whereas the fundamental rights are 11 conferred upon citizens with corresponding obligations of the state, the directive principles lay down specific duties of the state organs in conferring. Fundamental rights, freedom of individual citizens reviewed as individuals were sought to be protected, but in giving specific directives to state organs, the needs of social welfare, to which individual freedoms may have to yield, were put in the forefront. A reconciliation between the two is to be always attempted whenever this is reasonably possible. But there could be no doubt in cases of possible conflict which of the two had to be subordinated when found embodied in laws properly made, P. 961-865, Motilal v. Government of the State of Uttar Pradesh, ALR 1951, SC 257-296, Balwanal Rai Union of India, AIR 1968, all 14 referred to. There is a well-known distinction between political sovereignty and legal sovereignty. Legally, the British Parliament transferred the whole of its legal sovereignty over the people and territories of this country to the Constituent Assembly. Thus, legal sovereignty was vested in the Constituent Assembly, whereas the people of India may be said to be only politically sovereign. The political sovereign operated outside the ambit of law, yet made its impact and effect felt upon the legal sovereign, the Constituent Assembly, in recognition of this fact and to bring out that it was really speaking on behalf of the people of India. The Constituent Assembly began the preamble with the words, "We the people of India." This meant nothing more than that the Constituent Assembly spoke for the people of India, even though it was vested with the legal authority to shape the destiny of the country through the Constitution framed by it. There is not to be found anywhere in the Constitution any transfer of legal sovereignty to the people of India. The Constitution is the legal sovereign recognized by courts, although the ultimate political sovereignty reside in the people. The sovereignty of the Constitution is a écriture. 68 Supreme Court reports, 1973. Subcrenerant in a genuine whole, it is not vested in all its aspects in any one of the three organs of the state, but may be divided between them. The Constitution divides or distributes legal sovereignty into three branches or organs of the state: the legislative, the executive, and the judicature. The sphere zero-dollar sovereignty of each is sought to be so demarcated by our Constitution that the genuine whole appears in the form of three intersecting circles. In those portions of these circles where the judicial power intersects the legislative and the executive powers, the judicature acts as the supervisor or guardian of the Constitution and can check legislative or executive action. But in the remaining parts of the two intersecting circles of the legislative and executive spatres, the two other branches are supreme legally, just as the judicature is in its own. The judicature is the ultimate testing authority, as the guardian of the Constitution, insofar as the ordinary lawmaking is concerted in the sphere of primary fundamental law of the Constitution, lies also the amending power, contained in Article 368 of the Constitution, over which the control of the dicey law of the Constitution, 10th EDN p. 73 Ernest Barker, Principles of Social and Political Theory, 59, 613 Lasky Grammar of Politics, 296-297 referred to. The Constitution is based on the assumption that it is a means of progress of all the people of India towards certain goals. The direction towards which the nation is to proceed is indicated, but the precise methods by which the goals are to be attained are left to be determined by the state organs of the future. One generation has no right to tie down future generation to its own views or laws, even on fundamentals. We cannot infer from anything in the language of the unamended Article 368 any distinction beyond that found in the more difficult procedure prescribed for amendment of certain articles between more and less basic parts of the Constitution. The function of the amending